So if you were worried that these buyer agent agreements are going to create liability for sellers or listing agents, or that it institutionalizes steering, and that steering may be immoral or a crime, the DOJ agrees with you. My name is John McConnin. I'm a real estate attorney and a broker. And with the deal here, I cut and paste it. There's a few takeaways from this memo that they sent in to the class action judge 5 days before the case settled. Might have been 6 days. Right before this case settled about a month ago. It's December 2024. And this is a statement of interest in the United States. I thought it was very cute. Maybe it was motivated by it looking like Trump could win or did win. I don't remember the exact day, but it was around that time this came out. And the first takeaway, and this is probably good news, is that the proposed settlement, which is now settled, expressly allows offers of compensation to continue and for them to be posted publicly. This is radically different than almost every realtor's telling their sellers. Radically different than almost every trainer on the internet saying. But I'll tell you right now, I've been saying it from the beginning. It is still legal, at least in California where I'm licensed, for sellers to offer buyer agent compensation and to post it ahead of time. And of course it is. Just think about this. The seller does not care whether the agent calls themselves a buyer agent or a listing agent. If the seller can legally offer you as a listing agent compensation to bring a buyer to the property, they can do it to the buyer's agent. If that were illegal, then it would be illegal. And then there's no point in being a licensed real estate agent for residential real estate. So I don't see how that could ever go away. It just has to be done properly and legally. And that's the heart of this. You see, NAR rules are hamstringing agents and I think causing them to do institutionalized steering. And that's what, here, I'll go through this. These are the things I cut and paste out, so I've already done the work. Let's review. This was cut and paste right out of this opposition to the settlement that they fired. And it's opposition. If they really were in opposition, they wouldn't have filed it 5 days before, in my opinion, my legal opinion. The proposed settlement also introduces a new NAR rule that requires buyers and brokers to enter a written agreement before the buyer tours any home. Now, they're saying, they're establishing here their right to do this. And because the U.S. was not involved in the litigation of the settlement, the proposed settlement or new NAR rules implementing that settlement afford no defense to any such enforcement actions. So they're saying, just because of this Burnett settlement doesn't mean realtors are out of the woods with respect to these issues. And there's other class action suits pending all over. So the lawyers are already going to be aware of this. This is not a defense to their class action suits unless it's determined there's res judicata on that suit with respect to these issues and this rule. And in state suits, I don't think there would be. Well, there's no reason for me to opine on that. Just say there's a good chance many suits will not be res judicata on those won't be identical issues to these, so res judicata may not apply to them. So it's no defense. They're saying it's no defense because the U.S. wasn't there. Now, because the DOJ wasn't there. In addition, the new provision that requires buyers and brokers to make written agreements before home tours may harm buyers and limit how brokers compete for their clients. It bears a close resemblance to prior restrictions among competitors that courts have found to violate the antitrust laws in other proceedings and could limit rather than enhance competition. Of course it is. It's causing steering. We know the training is already on the net. I put these videos out. I'm sure the DOJ has been watching my videos because I seem to be anticipating these things by days. Like when NAR had CAR had forms for realtors to do this, I was like, how can they be doing this? They're not licensed to mitigate the risk, create the forms, explain the risk to the sellers. DOJ got in touch with, right, apparently after I put up my videos and removed those forms, CAR removed those forms to comply with DOJ concerns. How can this be happening? They're institutionalizing steering. Think about this. Right now, the NAR rules are saying realtors, buyers' realtors have to tell their agents, tell their buyers they're going to charge X percent. Let's say it's 2% or $20,000. It should never be a percent, in my opinion, if you want to be safe, because percents can compromise the duties of buyers' agents by making their clients pay more. They get paid more. So that's not really aligning with the duty. So if you're going to be offering buyer agent compensation, do it as a flat fee. Now, that flat fee comes in. Buyers agree. I'll pay my agent $20,000 if they help me buy a property. Now, the agent's going to say, will you pay me that $20,000 out of cash if the seller offers nothing? The vast majority of buyers will say, no, I'm already extending myself to buy this home. My payments are in there. I don't want to come up with an extra $20,000 cash. I might need that to improve the property. So the agent's then going to say, well, therefore, I won't be showing you homes where they're offering zero. And so agents are calling ahead of time and saying, are you offering compensation? Are you willing to offer compensation 2%? How likely am I going to get it? All of these conversations are happening. I know that agents are actually charging more than they used to in some cases. I've already heard of transaction closing that way. Agents that would have worked for 2 or 2.5 are now getting 3 because they read it ahead of time. So they're going to be steering their clients away from the properties that aren't offering the amount they put in writing and steering them towards properties that are. Ironically, I'm telling all sellers, if you do it properly, you should definitely be, instead of just being passive and accepting these offers, advise your realtor to advertise that you're offering buyer agent compensation, and everyone should show up this weekend and make offers, and we'll be offering 3% or 2% to buyer's agents upon a successful close. I mean, why not take advantage of the situation? I go into much more in-depth later, but let me just have people understand what's going on here. We see one, buyer agent compensation may be broadcast, and it may be broadcast if done legally, and risks are mitigated and explained to sellers. Realtors aren't licensed to do that. That's why Carr took those forms away from realtors. But a realtor, if they're really trying to help their client sell more to multiple offers, should do just what they did in the past. They go in there and say, I get 3%, but if we offer 2.5%, 3%, we're going to have motivated agents bringing their motivated buyers to make offers on your property after they see your home if they like it, and you're going to sell for more money. That's what realtors used to tell people. It's still true. The only difference is you're just not putting it up on the MLS, which now is an advantage for sellers that can do good marketing efforts to buyer's agents. It's an advantage. And listing agents who really care about their sellers are going to explain this to them. Because there's almost no advantage, I see legally, to sit there passively and wait for the offers to come in. The offering buyer agent compensation is a risk, whether you broadcast it, which is not illegal, or you just wait and negotiate it later. There's really only one thing a realtor can advise their clients to do safely, is offer and never agree to buyer agent compensation. Let us market your home, do a great job. Some of those buyers will want to see your property and they'll just bypass their agent. Some of those buyers won't have agents. So just go on the MLS. The marketing's going to be done great. We'll do local marketing. We'll have open houses. We'll try to sell your home for more for a week or two. And then if we're not getting the offers that you like, then consider broadcasting buyer agent compensation. That is the truth. That's what realtors should be telling their sellers. Now, how do realtors do it without the forms? Well, they can't. But they can if they're certified seller advocates. So if you're a realtor, go to gettingclientspro.com. On the front page, it'll say for realtors. You click on it, and you'll see where you'll get one of the forms, the most necessary form right off the bat, and you'll see what I'm offering. Right now, it's super inexpensive. It may be more in the future, but right now, it's December 2024. As a realtor, you should seriously consider it's almost no skin off your back, because I'm trying to get this process institutionalized to avoid the institutional corruption that is being caused right now by these buyer agent agreements. It is my opinion that if you're letting your sellers agree to pay buyer agent compensation upon request, and there's a buyer agent agreement that has locked in the amount the buyer agent's going to be paid, and believe me, if they're a NAR realtor, they're probably doing it. If they're not a NAR realtor, they're probably not doing it. So it's actually, I'm going to revise what I previously said. You can negotiate buyer agent compensation with licensed real estate agents who are not NAR realtors. But if they're NAR realtors, you're institutionalizing crime or immoral anti-competitive practices. Now, and I'm serious about that. That's what DOJ is essentially saying. They've said steering is a crime. Steering is a crime in many circumstances, and they define steering here. I'll give you what I wrote, is steering part of antitrust concerns DOJ? This is what the AI said. In context of antitrust concerns, steering refers to a practice where a company, like a health insurance, uses contractual clauses to prevent patients from choosing lower cost providers, essentially steering them towards specific healthcare providers within their network, which the DOJ of the Department of Justice considers an anti-competitive practice that can violate antitrust laws. So let's go back and see. Well, I know I already did this, right? So, it bears a close resemblance to prior restrictions on the competitors that courts have found to violate antitrust laws and proceedings that can limit rather than enhance competition for buyers among buyers brokers. They actually in here, thus the concerns remain the broker agreement may limit how brokers can. Here it is. This is the very similar language to what we just read here, right? Thus, the concerns remain that broker agreement rule may limit how brokers compete, and there is no record available in the current posture addressing this concern. It is therefore important that any settlement not purport to preclude future antitrust scrutiny. This is scrutiny especially easy with respect to price fixing and steering. It's plain as day. So the takeaways are, if a realtor is going to be involved in a transaction with a NAR realtor working with the buyers, you better tell your sellers there's a risk to offering that buyer agent compensation, and there's ways to mitigate against it, and you want to use certain forms, and you probably should put, at no extra cost to you, Mr. Seller, if you're going to offer $20,000, offer $19,000, and then make sure $1,000 is on the HUD for a buyer agent, and then make sure that the buyer goes through this process of understanding how they're getting paid, that their money's being used to buy the property, that their money could have been used to buy down the price, and that they're doing it. You're agreeing to offer them compensation to make sure that they're well advised by a realtor and a seller, and that it's not been done for the purposes of steering. And in fact, I think it could be argued broadcasting it ahead of time is better, because by broadcasting, you're not selectively letting this happen. The potential buyers could be finding out that buyer agent compensation is being offered on this property. So it's flipping the process on its head. But the crazy thing is that the exact opposite. Okay, so the price fixing, the rigging prices ahead of time, that hasn't been solved. Price fixing, to some degree, because if agents follow my practice, they're not pre-negotiating the amount, that may be solved. But the way the realtors took this class action settlement, actually, if steering is a crime, it's industrializing crime. If steering is immoral and anti-competitive, pre-negotiating rates for the entire transaction before even seeing a home is a hell of a monopolistic practice. They're saying you can't see the home if you don't agree to pay me. I can't help you see this home if you don't agree to pay me. And if a listing agent advises their seller to participate in this practice, that is, agreeing to pay, the listing agent may be condemning their seller to 4 years of financial purgatory, or whatever the statute of limitations is in your state. Because lawyers are going to know that if they have a disgruntled buyer who's not happy with the price they paid at the time, the prices went down, they found defects in the property or other problems, there might be very low-hanging fruit in that transaction because they engaged in what the DOJ has said is an anti-competitive behavior or steering. So there are solutions. My first solution would be to go to Getting Clients Pro if you're a realtor. Buyers and sellers, I guess I'm telling you, go to winnerscheck.com, which is the website that this video is being posted on YouTube, and I'll have a link for how you can get an agent that follows the right practices. My name is John McConnin. Thank you. I'm an attorney, and many, many, many more videos are coming out on this. Thanks. Bye.